Many people lose their fall cases as a result of poor documentation. Today, let's explore Florida's slip and fall law and 8 things you can do to help increase your odds of success. Hi everyone, Justin Presser here. Happy Friday and welcome back to another Presser Law, Fridays at 5. Slip and fall and trip and falls are some of the most common injuries after motor vehicle crashes. In fact, they're so common Florida has passed a statute outlining what injury victims need to prove in court to hold a business accountable for their injuries from a slip or trip and fall. This statute requires a slip and fall or trip and fall victim to prove that the premises owners of a business establishment had actual or constructive knowledge about the dangerous condition that caused the fall or created the dangerous condition. So what's the difference and how can you document this incident? Glad you asked. Actual knowledge involves a business or its employees having actual knowledge that a dangerous condition exists on a floor and not correcting it before someone falls and is injured by it. This is different from constructive knowledge, which imputes the knowledge of the dangerous condition onto the business if it was present there for a sufficient period of time or occurred with such regularity that it was foreseeable. An example of constructive knowledge may include drop food at a grocery store. If the store does not clean it up in time and it causes someone to trip and fall or slip and fall and injure themselves, the grocery store may be held to have constructive knowledge of that condition on the floor. Both of these require some form of knowledge. However, where a business was actively negligent in creating a dangerous condition which injures someone else, the focus is on what the business did and not whether the business knew or should have known about the dangerous condition. Now, as you might have guessed, injury victims have a lot to prove if they're hurt in a slip or trip and fall. Here are some suggestions on how you can protect your injury claim after a fall. 1. Note the area where you fell and what you slipped or tripped over. 2. Photograph the substance or condition that caused you to fall from various angles and distances. Don't just take close-up pictures. We want to see the surrounding areas and what they look like as well. Number 3. Write down any statements you recall from any employees, especially if those statements indicate that the employees knew of the dangerous condition. 4. Obtain the names and contact information of any witnesses at the scene. Don't rely on the business to take this information and store it for you. Number 5. Obtain a copy of any incident report you're asked to fill out. Number 6. Photograph any visible injuries. As time passes on, these injuries will begin to fade, so it's important to document them from the outset. Number 7. Preserve any clothing that may have any of the substance that you slipped on, and save the shoes you were wearing at the time of the fall. Finally, number 8. Contact an injury attorney. The faster you contact an injury attorney, the faster we can begin an investigation of your claim and documenting everything we need to know. While you will hopefully never be injured due to a slip and fall or a trip and fall as a result of some sort of dangerous condition, if you are, hopefully you learned a little bit today about what you need to do to protect yourself. For more information or to check out some of my other videos and blogs on various topics, please visit www.findyourjustice.com. We'll see you back here next Friday for another Presser Law, Fridays at 5. Presser Law, fighting for justice, fighting for you.